Substantial principles of the criminal cases. Criminal case must adhere to the following substantial principles. So it is up to the lawyers to be sure that these substantial principles are being respected. Being held in public, except the camera ordered by the court. Being fair and impartial. Respect for the right to defense and the legal counsel. Adversarial proceedings and the equality of parties before the law. Somebody talked about the equality of arms. I think the principle of equality of arms in a criminal trial. So most importantly, the fifth says, basing on evidence lawfully produced, being rendered within the time limits prescribed by the law, with the judgment and being rendered in the language used in the pleading. What does it mean here? Don't hesitate to raise illegal evidence if it is going to be used in your case, in the case of your client, of course. Mr. President, my client was detained more than 5 days, and it is, according to the criminal procedure law, called illegal or unlawful detention. And from a fast statement, from an illegal detention, you cannot continue to detain somebody. So first of all, I request you to release my client, and then we are going to be back on the regular procedure. Otherwise, from irregular procedure, we may not reach to the regular proceeding. So it is very important to note that whether pre-trial proceeding, whether trial proceeding during the trial phase, these principles have to be respected. And because they are very for the public interest, they are, comme je disais tantôt, c'est des procédures d'ordre public qui doivent être respectées par tout le monde, y compris le juge lui-même ou le procureur. Donc, ce n'est pas à lui de décider parce que le dossier était très important et donc on a été obligé de dépasser les délais. Donc, les 5 délais pour l'investigateur ou l'officier de police judiciaire et les 5 délais, plutôt les 5 jours pour l'officier du ministère public. Donc, c'est à nous de les soulever à tout état de la procédure. Another issue that's very important here is what we have to do. During the pre-trial phase, I hope that any lawyer has to be sure that the court has a jurisdiction. The law says, a judge ruling on provisional detention will have the following duties: to see whether he is or she is competent to hear the provisional detention case brought before him or her. And who is the competent judge? According to the new law, it is the one that is nearest court. Here it is very clear, it is nearest court of primary court. So no provisional detention proceeding may start at the intermediate court. So that one has to be respected. To verify the legality of the provisional detention warrant, that was what I meant previously. 5 days for judicial police, 5 days for prosecutors. And remember, these 5 days, they do not concern the official holidays. So official holidays have not been counted in these days. Okay. Issue. I think we used to respect only number 3. Only number 3, that is to examine whether there are grounds for termination of the prescription. That was actually said. Is there any reason that can burden, that can forbid the prosecution to continue to detain your client? Whether prescription, whether any other reason that can terminate the public action. I think in Rwandan criminal procedure law, there is actually around 5 reasons or 6 reasons that cannot allow the prosecution to actually prosecute. What we used to call in French, les raisons d'extinction de l'action publique. So The last one is actually is there any serious grounds for thinking that the person has committed an offense? So that is very important. There comes, once again, a debate difference between serious grounds and evidences. Do we have to talk about evidence during the pre-trial proceeding, or we talked about evidence during the trial phase? It is very debatable. Otherwise, what prosecutors call serious grounds are the same evidences during the trial phase. I don't think they change according to the phase or the step they are brought before. So, finally, it is for the lawyer. I learned during my profession that, and my mentor used to say that, good lawyer, absolutely, a good lawyer has, in any case, at least one motion, one exception, especially when it favors your client. Mr. President, and I think in these particular issues, whether provisional release because my client is sick, because my client is a family member, because she's a lady, she has children. In the interest of the children, please, I request you, I pray you to grant him provisional release, blah, 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 blah. And very important, for any offense, even the serious one, even the serious felony in Rwandan criminal procedure law, you may be granted provisional release if it is motivated, it is reasoned by the judge. So I remember people used to say that there is no provisional release for serious grounds, especially, I think you remember the issue of Peter Linda. Do you know why he was released? He is an American professor, an American scholar, who was detained here. But the judge granted him provisional release due of because he was sick. And the judge said, I think we should prioritize, Daddy. We should give the how do we say, Jibe? Yeah, no, not benefit of doubt. He said, I think we should favor the client who is seen to be sick before actually prevailing the interest of the justice, because half of the person prevailed than justice, which was very, very interesting. And people have started to actually bring it before judge. You say, please, in a particular case, sorry?
People have been using the sickness.
Yeah, sickness as the reason to be granted the provisional release. So it is very important for lawyers to see any kind of reason to raise a motion before the court goes further, just to obtain at least a very small thing on the interest of your client. So issues concerning pre-trial motions. One of the important that I found, by concluding, I may say, it was actually the motion for release and the issues to challenge illegal evidences that actually lawyers used to do in every case when you think they are linked with the right to have a fair trial principle. By this, I can actually thank you so much for your attention and ready to respond to your questions. Ready to discuss because I'm not lecturing, you know even better than me. Thank you so much, Bagabu. I can give you the floor.
Thank you very much. I want to come back on the issue of the power of the prosecutor to release or to close the file because maybe there is no evidence or the objections that you raised as res judicata and so on. But let me come back on the public nature of offenses. Let's give a very short example. On a case of embezzlement of a private institution, whereby the parties decide to solve the issue. Maybe the party pays the money. Can the prosecutor close the file?
Nolo prosequi. Yeah, sometimes nolo prosequi does not favor the civil parties, but this is the case. Do you think, and sometimes I remember he had the case, even the case on the process, whereby the prosecutor comes. They wrote. They didn't even come before the court. They wrote, Mr. President, we hereby say that we no longer have any case against. He's actually. I don't like. He's a doctor. Doctor XY. Why? Because we request his release because he was detained, and we do not have any case in the merit. So you don't need to hear the case in its merit because we do not have any case against him. As a co-accused say, no, Mr. President, it is not important because it is going to... ça va porter préjudice à la justice, la vérité ne sera pas connue, blablabla. Bla, bla, bla. Mais enfin, le juge a dit, c'est lui qui est accusé. Aujourd'hui, il vient dire, je n'accuse plus, je n'ai plus de preuves contre lui, donc je veux que vous mettiez fin à la procédure. Et ça a été accordé. Normalement, c'est très rare de la main levée de la détention provisoire, mais aussi la procédure selon laquelle nous n'avons aucun dossier contre lui, nous ne voulons plus le poursuivre. Parce que le monopole de la poursuite appartient au ministère public. S'il vient aujourd'hui dit, nous n'avons plus intérêt de poursuivre cette action parce qu'il est le monopole. Il a le droit d'être présumé avoir le monopole de connaître l'intérêt général de la population. Parce que la justice étant rendue au nom du peuple, il peut venir et dire, s'il vous plaît, nous on ne poursuit plus. Normalement, ce que nous avons l'habitude de constater, c'est le principe de la liberté, plutôt la plume. Je suis lié par ce qui avait été écrit dans l'acte d'accusation, mais moi, en tant qu'officier du ministère public, je constate que ça ne vaut pas la peine de continuer parce que ceci, parce que cela. Donc, dans les hypothèses, c'est possible, ça a déjà été fait, du moins dans ma petite expérience professionnelle au niveau de dossier.
Sorry, my question goes, is it a favor to discontinue the case because the parties that have filed the case have...
What is your interest? My job as a lawyer, defense lawyer, is actually the interest of my client. I'm not here for the public interest. I'm here just for my client's interest.
No.
In that particular case, it is in the favor of my client. For me, I'm satisfied.
You didn't get me well. I'm asking the prosecutor to discontinue the case because the parties have settled the issue.
Yeah.
Is it a favor or it is a rule that you can claim as a lawyer? Suppose you are a lawyer,
and
then the parties have
settled the case.
Their cases.
Yes.
You go to see the prosecutor having the file.
Yeah.
You ask him or her, please, prosecutor, you can close the file because the parties have settled the issue. Then he tells you, lawyer, this is of public order. I don't have any right to discontinue the case because settling the issue is civil, but the offense is...
No, it's not civil. It is criminal. It is provided under the criminal procedure law. Amicable settlement of the case, it is under criminal procedure law. It is criminal. It is provided only for misdemeanors.
For misdemeanors.
Misdemeanors and contraventions.
Yes,
not for felonies. Yes.
Not.
Yes, but it is allowed in the criminal procedure law.
Okay.
Yeah. Yes, Counsel. Ndahayo and then Counsel.
That amicable settlement is done where the prosecutor can decide to close the case upon the agreement between the parties, the accused and the victim, is done on crimes that have a maximum penalty of 2 years. So
and under Rwanda law, maximum 2 years are misdemeanors.
Yeah, exactly, exactly. So if the crime is falling under that category, at any time the prosecutor can try to mediate or even...
It is a plea bargaining à la Rwandaise.
Yes.
Yeah.
Thank you.
Thank you. It is a plea bargaining à la Rwandaise. That was I may say. It is actually plea bargaining in Rwandan context. Yeah.
Thank you. I want to return on the cross-examination. In our law, the law provides the cross-examination, but in the court, this is not applicable. I want to know
It is
why.
applicable. If you don't raise it, the judge is not going to raise it. The judge is not to accord you it if you do not actually raise it, because I've already exercised so many times. So many times. I remember I challenged the witness of the prosecution from morning up to 12. I sent to the court 72 questions that I'm going to be using in cross-examination. I've already used it, and it is very acceptable. And it paid.
But you challenge it upon on the written testimony of the witness. But the prosecution did not bring the witness in the court.
No. The obligation to bring the witness in the court is up to the court. Because it was actually an objection. Mr. President, before the beginning of the case, I request you, because I'm going to challenge the prosecutor's witnesses, please remember, I don't know when you are going to invite them, please remember, please note that my client and myself, we need to cross-examine them. Whether you invite them before or at the end of the trial, remember that we need to cross-examine them. And the court said, un jugement interlocutoire, un jugement vendu droit. We accept that we are going to bring them to be cross-examined. And they did.
Okay.
Yeah. Jacques a déclaré la session close, et quand Jacques a décidé, je ne peux pas continuer.
Just one question. One question, sir.
My French is bad, but even though I understood that, okay.
Thank you very much. If we look at the procedure and also the Constitution, it's stated that all the parties are equal before the courts of law. In criminal matters, the prosecutor is one party representing the public, and the lawyer is another party representing an individual. We've seen, actually, it is a general practice that prosecutors present written evidences, testimonies, of which we do not know under which circumstances they collected those particular evidences. But as a lawyer, you cannot just submit papers that it is the testimony from your witnesses. You have to present that witness in court. Is that practice consistent with that particular provision that I just mentioned? Thank you.
The issue of a civil law system, whereby prosecutors have the duty to prosecute and duty to exculpate. L'instruction à charge et l'instruction à décharge. I used to say that it is one of the complicated roles of the prosecutors to whether be looking evidences that incriminate the person and looking evidences that can actually allow the in discharge, we use instruction à charge and l'instruction à décharge. It is very important. But here, by having that side of Rwanda going in common law system, we are not actually allowed. I don't know if we at least at a certain level allowed also to investigate, to carry out investigations and bring them before judges, so the judges to refute them. Mr. President, I have heard witnesses, and it seems it is very contradictory to the witness, to the deposition made by the prosecutor's witnesses. So I want you to bring him here. You know that sometimes judges say, we do not have interest to bring them here. So it is very important to bring the appearance, to request the appearance of the witness so that to be cross-examined. This is what you said, and this is what you are saying now. And then you raise the issue of the contradictions in your client's favor. Yes, it is for the prosecutors, but it is not forbidden as we are going in common law systems, whereby all parties are equal and all parties have the duty to bring their own evidences, so that it has to be on the balance of the judge to say that one has the weight, that one does not. So I think we should actually have the... nous devons absolument essayer, avoir l'audace de commencer. But I know one guy who did that and the judge accepted, and it is here in this country, even though it was a little bit not very normal in civil law system.